Today, I am Jennylyn C. Mondejar, and today we will discuss about grave coercion. Article 286, Grave Coercions. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who, without authority of law, shall, by means of violence, prevent another from doing something not prohibited by law, or compel him to do something against his will, whether it be right or wrong. If the coercion be committed for the purpose of compelling another to perform any religious act or to prevent him from so doing, the penalty next higher in degree shall be imposed. In the case of George B. Navarra versus Office of the Ombudsman, GR number 176291, the facts of the case are as follows. Far East Network of Integrated Circuit Subcontractors Corporation, or Phoenix, lists the premises of Food Terminal Incorporation, or FTI, in Taguig, Metro Manila, from 1995 up to 2002. It appears that before the expiration of the leased contract, or on the night of September 16, 2002, armed elements of the FTI took over Fiate's premises and forced two building custodians to leave. Armed FTI policemen were guarding the perimeters, and FTI employees had forcibly opened the door to the building and had gone inside. FTI contended that Phoenix owed unpaid rentals, and among other things, that FTI was merely exercising its rights under the compromise agreement forged between FTI and Phoenix. Ombudsman dismissed petitioner's complaint since record shows that FTI gave several demand letters to Phoenix but went unheeded. So, there was no grave coercion since employees of Phoenix voluntarily opened the gates for FTI policemen to enter. Hence, this present petition. The issue in this case is whether or not grave coercion is present. The Supreme Court held that yes, all the elements of grave coercion were exempt. For grave coercion to lie, the following elements must be established. 1. That a person is prevented by another from doing something not prohibited by law or compelled to do something against his will, be it right or wrong. In this case, private respondent prevented petitioner and his employees from entering their own premises. They had also compelled petitioner's caretaker to leave the premises against their will. Number 2, that the prevention or compulsion is effected by violence, threats, or intimidation. In this case, when private respondents entered Phoenix compound in the evening, they had a contingent of about 20 to 30 armed personnel as against petitioner's two caretakers. They forced their way into the gates, threatened the caretakers and a driver, and admittedly destroyed one padlock and welded the gates to prevent entry. 3. That the person who restrained the will and liberty of another has no right to do so, or in other words, that the restraint is not made under authority of law or in the exercise of any lawful right. In this case, the possessor of the Phoenix compound exhibited its opposition to any takeover. Certainly, private respondents had no right to enter the compound and evict the occupants against their will. They had no court order to evict the existing occupants.